Okay, order to give security. I'll be starting from section 117, order to give security. If upon such inquiry it is proved that it is necessary for keeping the peace or maintaining good behavior, as the case may be, that the person in respect of whom the inquiry is made should execute a bond with or without sureties, the magistrate shall make an order accordingly. So in 116 there will be an inquiry which will be conducted, and upon the inquiry, if upon such inquiry it is necessary for keeping peace कि security लेनी चाहिए, then the magistrate will make an order accordingly. So now this says inquiry is done and it is necessary. So after the inquiry, two things is possible: that it is necessary, it is not necessary. So if it is necessary, then what will happen? The magistrate will order for the security, and no person shall be ordered to give security of a nature different from or an amount larger than for a period longer than that specified in the order made under section 111. So when such order is made, there are certain conditions which needs to be followed. So in 111, the executive magistrate makes an order. The first condition is that the amount cannot be larger than that, and the period cannot be longer for that. So there are two things: one period, दूसरा amount. Okay, an amount of every bond shall be fixed with due regard to the circumstances of the case and shall not be excessive. So that is reasonableness. When the person in respect of whom the inquiry is made is a minor, the bond shall be executed only by his sureties. So here the bond can be with or without sureties, but in case of minors, it has to be with surety. So there are three conditions. If in case after the inquiry magistrate feels that there should be second, कॉल नहीं कर सकते okay. So this is the situation. Now 118. If on an inquiry under section 116 it is not proved that it is necessary for keeping the peace or maintaining good behavior, as the case may be, that the person in respect of whom the inquiry is made should execute a bond, the magistrate shall make an entry on the record to that effect, and if such person is in custody only for the purpose of the inquiry, shall be released, and if such person is not in custody, shall discharge. So this is the second condition. So inquiry is done, and post inquiry we found that there is no necessary to get the bond executed. In such situation, the magistrate will record this, and in case the person is in custody, he will be released. If not in custody, then he will be discharged. This is 118. So we have done 116 inquiry, 117 and 118. 17 is when they are found, 118 is when they are not found. Now we'll be dealing with 119. Commencement of period for which security is required. If any person in respect to whom an order in requiring security is made under or section 117 is at the time of such made sentenced to or undergoing a sentence of imprisonment, the period for which such security is required shall commence on the expiration of such sentence. So 106 is the power of the sessions court or the judicial magistrate first class to order security for peace in certain offences for 3 years on sentence. Okay. And 117 is the order of security for keeping peace by executive magistrate. So in these two sections, if at the time when such order was made the person was already undergoing some sentence, then in such situation the time period of security will commence after the expiration of such time period. Okay, now let's start with In other cases, period shall commence on the date of such order unless the magistrate for sufficient reason fixes a later date. And so there are two situations, 119. So this is about the time period of commencement. Two situation, already under sentence and other situation. If already under sentence, after the expiration. Another situation, from the date of order, और उसका भी एक एक्सेप्शन है और ये उसका एक्सेप्शन है. ओके, just erase all of this. So that it looks clean, and we will now move forward. 120. Content of bond. The bond to be executed by any such person shall bind him to keep the peace or to be of good behavior, as the case may be, and in the later case the commission or attempt to commit or the abatement of any offence punishable with imprisonment wherever it may be committed is a breach of the bond. Okay, now since we are keeping the security for making peace, maintaining peace and good behavior, but in case there was a commission, there was an attempt, there is an abatement in any offence punishable with imprisonment wherever it may be committed, not just where the place where the court has taken the security. It is not, for example, this is the court which has taken security from person A, but offence was committed here. Now in this jurisdiction the bond has not been taken, but the person has committed some breach, then this will also amount to be a breach of the bond. Now, power of magistrate to reject securities. A magistrate may refuse to accept any surety offered or may reject any surety previously accepted by him or his predecessor under this chapter on the ground that such surety is an unfit person for the purpose of bond. So what is the ground? Surety is unfit person. In such situation, already previously accepted, even the previously accepted or refused to accept any surety, even the previously accepted by the predecessor also, they can challenge the order of predecessor in case the surety is unfit for, provided that before so refusing to accept or rejecting any such surety, he shall either himself hold an inquiry on oath into the fitness of the surety or cause such inquiry to be held and report to be made thereon by the magistrate subordinate to him. So this is the ground is unfitness. How you will determine the unfitness? By holding an inquiry. So you hold an inquiry, you determine the unfitness. Such magistrate shall, before holding the inquiry, give reasonable notice to the surety and to the person by whom the surety was offered, and shall, in making the inquiry, record the substance of the evidence adduced before him. So before the inquiry, you give a reasonable notice. To whom you give the notice? You give notice to two people. One is the surety and second is the person who is giving such surety. And then you will record the substance of the evidence. Now, if the magistrate is satisfied after considering the evidence so adduced either before him or before the magistrate deputed under subsection 1, and the report of such magistrate that the surety is an unfit person for the purpose of the bond, he shall make an order refusing to accept or rejecting as the case may be. Now here the order is being made. So you conduct an inquiry. Before the inquiry you send a notice. The party will produce some evidences that will form a record. On the basis of the record you give an inquiry and you give an order, if it is an unfit or not unfit, provided that before making an order rejecting any surety who has previously been accepted, the magistrate shall issue his summon or warrant as he think fit and cause the person for whom the surety is bound to appear or to be brought appear before him. Okay, so these are the section. Now let's revise. 16 say we started, 117 we said yes, 118 we said if not fit, 119 is dealing with period commencement, 120 deals with content of the bonds, 121 rejecting securities. Okay, 119 20 में you either what are the contents of the bond, 121 power to reject. Okay, done. Okay, now 122 imprisonment in default of security. If any person ordered to give security under section 106 or 107 does not give such security on or before the date on which the period for which such security is to be given commence, he shall, except in cases next hereinafter mentioned, be committed to prison, or if he is already in prison, be detained in prison until such period expires, or until within such period he gives the security to the court or magistrate who made the order requiring it. So this is the in default. What will you do? Commit to the prison. These are the only 2 points to remember in this section. Oh no, wait. Now, so in case of default, you commit a person to the prison. Now, if any person, after having executed a bond without for keeping peace in pursuance of the order made under section 117 is proved to the satisfaction of such magistrate or his successor in office to have committed a breach of bond, such magistrate, after recording the ground of such proof, order that the person to be arrested and detained in the prison until the expiry of the period of bond, and such order shall be without prejudice to any other punishment or forfeiture to which the said person may be liable in accordance with the law. So this is with respect to 116, 106, that is Sessions Court and the JM1, and this is with respect to 117. In both case, default, you detain the person in prison. Now, when such person has been ordered by the magistrate to give security for a period exceeding 1 year, such magistrate shall, if such person does not give such security as aforesaid, issue a warrant directing him to be detained in prison pending the order of the session judge, and the proceeding shall be led as soon as conveniently may be before such court. So this is a special case which applies only when the security is for more than 1 year. In such case, you issue a warrant of arrest pending orders from session judge. Okay, such court, after examining such proceeding and requiring from the magistrate any further information or evidence which it thinks fit necessary, and after giving the concerned person a reasonable opportunity of being heard, may pass such order on the case as it thinks fit, provided that the period, if any, for which any person is imprisonment for failure to give security shall not exceed 3 years. So this is a limit. This is very important. So in 100 and section 22, we are talking about default. In case of default, it can be prisoned, and that maximum is 3 years is the maximum time period for which the clause 1 इसमें clause 1 talks about sessions court, clause 2 talks about the executive magistrate, clause 3 talks about when the security is for more than 1 year, and in how many cases it is 1 year. So executive magistrate is empowered to get security first when there is suspicion that there is a breach of peace. In this, the maximum time period is 1 year. Second, when the person is disseminating some seditious material, objectionable material, or obscene material, unless then also 1 year. Third is the person is concealing himself or committing some cognizable offense, then also 1 year. Fourth is 110 where the person is a habitual offender. Here only the executive magistrate has a liberty to take security for more than 3 years. And other cases where the 3-year security is taken is 106 when the person is convicted. So here two courts have the power, which is the Sessions Court and other is JM1. So this provision clause 3(2) is talking about security for a period exceeding 1 year. In such situation, the session court, order of the session court has to be taken. They will confirm it. Okay. Now, and maximum period in default is the 3 years. If security has been required in course of the same proceeding from two or more persons in respect of any one of whom the proceeding are referred to the session judge under subsection 2, such reference shall also include the case of any of the other such person who has been ordered to give security, and the provision of subsection 2 and 3 shall in that event apply to the case of such other person also, except that the period, if any, for which he may be imprisonment shall not exceed the period for which he was ordered to give security. Okay, this is just a procedural requirement. If there are two or more person and the case has been referred to the session judge with respect to one person, then the case of others person can also be referred to, and then subsection 2 and 3 will apply. 2 and 3 are with respect to 2 and 3 like 1 year होगा तो सेशन जज से कंफर्मेशन लेना पड़ेगा, एंड विद रिस्पेक्ट टू 3 it is about, it should not be more than 3 years. The session judge may in his discretion transfer any proceeding laid before him under subsection 2 or subsection 4 to an additional session judge or assistant session judge, and upon such transfer, such additional session judge or assistant session judge may exercise the power of a session judge under this section in respect of such. So this just talks about the transfer to whom? To two judges, ADJ or additional session judge, or assistant session judge, and they will be deemed to be a session judge for this purpose. Now, if the security is tendered to the officer in charge of the jail, he shall forthwith refer the matter to the court or the magistrate who made the order and shall await the order of such court or magistrate. So we have seen that the security can be taken from the person who is already in prison. So in this case, the security will be tendered to the jail officer. So this clause talks about that situation only, that if the security is tendered to the officer in charge of the jail, then in such a matter, it will be referred to the court who made this order and then await the order of such court or magistrate. Imprisonment for failure to give security for keeping peace shall be simple. So this is another condition, that it should be simple. We know that the imprisonment can be simple, can be rigorous, can be solitary confinement. So here it has to be simple only. Imprisonment for failure to give security for good behavior where the proceedings have been taken under section 108 be simple, and where the proceeding have been taken under section 109 or 110 be rigorous or simple as the court or the magistrate in each case direct. So there's also another qualification, that if it is for the 108 is a situation disseminating some material, so उस situation में simple होगी. 109 and 110, 10 is the habitual offender, 109 is person concealing himself, or he may be committing some cognizable offense, therefore he is hiding. These are the two. In this, it can be either rigorous or the simple as a court or the magistrate in each case direct. Okay, this is what it is. Now let's revise whatever we have done till now. So we did 117, which is order to give security. Let me erase it first. Now, so we did 117 where 116 inquiries being made, 117 where the person is found to have committed, 118 where person was not found. Now 119 we deal with commencement, when it will commence. Okay, 120 is the content and the content that it is for keeping security and how there be some breach. 121 we discuss about sureties, that the court can reject surety. It can either be the new one or the previously accepted one on the ground that they are unfit. Then we saw how this procedure will take place. So there is an entire procedure, there will be inquiry, there is a notice, there will be hearing, and then the order will be made. Okay, then we talk about 122, which is default, giving security. So in case of default we have seen that there will be imprisonment. Now first clause talks about 106, second clause talking about 117. Then we saw there are some conditions. For example, if more than 1 year is there, the session judge will confirm it. Session judge can give it to the additional or the assistant judge. It should be simple, but it can be rigorous in certain circumstances, which is 109, 110. So that's it. So these are the things that we have done. Now 123. When the district magistrate in the case of an order passed by an executive magistrate under 100 section 1817 or the chief judicial magistrate in other case is of the opinion that any person imprisonment for failing to give security under this chapter may be released without hazard to the community or to any other person, he may order such person to be discharged. So 122 may we have imprisoned the person in default of security. Okay, so in default, if we have imprisonment, that order can be vacated by the district magistrate or by the CJM. Whenever any person has been imprisonment failing to give security under this chapter, the High Court or the Court of Session, or where the order has been made by any other court, the district magistrate in the case of an order passed by executive magistrate under section 117 or the chief judicial magistrate in any other case may make an order reducing the amount of security or the number of sureties or the time for which security has been taken. So this is about imprisonment in case of default, and this is about the amount, the time, and the number of surety, and the power lies with the High Court or the Court of Session or the district magistrate. These are the three. So High Court when the session judge will make it, Court of Session when the judicial magistrate first will make it, and district magistrate when the executive magistrate will make it. An order under subsection 1 may direct the discharge of such person either without condition or upon any condition which such person accept. So here it talks about discharge. So section 3 is in continuation to with. It says when a person discharged, it may be either with the condition or maybe either without some condition, provided that any condition imposed shall cease to be operative when the period for which such person was ordered to give security has expired. For example, the person A was ordered to give security for 3 years, and in default of this he was imprisoned, but this order was vacated after, for example, 2 years only. Then in such situation and some conditions were imposed in lieu of that discharge, these conditions will cease to operate after the expiry of 3 years. This is the only thing. The state government may prescribe the condition upon which conditional discharge may be made. Now the rules will be made by the state government for the conditional discharge. So section 3 talks about conditional discharge. Any condition upon which any person has been discharged is in the opinion of district magistrate in the case of an order passed by any executive magistrate under 117 or the chief judicial magistrate in any other case by whom the order of discharge was made or of his successor is not fulfilled, he may cancel the same. This talks about failure to fulfill conditions. If that happens, when the conditional order of the discharge has been cancelled under subsection 5, such person may be arrested by the police officer without warrant and shall thereupon be produced before the district magistrate in the case of an order passed by an executive magistrate under section 117 or the chief judicial magistrate in any other case. So, clause 3 was the conditional release. You fail to follow it. If you fail, you will be arrested. That will be without warrant, and post-arrest will be taken before the DM or the CJM. Who will order the cancellation of this conditional release? The district magistrate or the CJM. Who will give you this conditional release? District magistrate or the CJM. So these are the two authorities in 123 that you need to remember: CJM and the district magistrate. Okay, unless such person gives security in accordance with the terms of the original order for the unexpired portion of the term for which he was in first instance committed or ordered to be detained, such portion being deemed to be period equal to the period between the date of breach of condition of discharge and the period on which and the date on which, except for the conditional discharge, he would be entitled to release. The district magistrate in the case of an order passed by executive magistrate under section 117 or the CJM in other case may remand such person to prison undergo such unexpired portion. The person remanded to prison under subsection 7 shall, subject to the provision of section 122. What is section 122? It is about default in payment. Okay, because 117 yes, 118 no, 119 the commencement of time period, 120 the content, 121 sureties, 122 default, 123 is about releasing a person, which we are doing right now. So 122 was imprisonment in default of surety. High Court or the Court of Session may at any time, for sufficient reason to be recorded in writing, cancel any bond for keeping the peace or for good behavior executed under this chapter by any order made by it, and district magistrate in case of order passed by executive magistrate under section 117 or the chief judicial magistrate in case other case may make such cancellation where such bond executed under his order or under the order of any other court in this district. So there is a concurrent power at any time. If there are sufficient reason which will be recording in writing, they will cancel the bond which is executed under this chapter. And district magistrate executive magistrate के केस में and chief judicial magistrate other cases में cancel कर देंगे such bond को. Any surety for the peaceable conduct or good behavior of another person ordered to execute a bond under this chapter may at any time apply to the court making such order to cancel the bond, and on such application being made, the court shall issue a summons or warrant as it think fit, requiring the person for whom such surety is bond. When a person for whose appearance a summons or a warrant has been issued under the provision of subsection 3 of section 121 or under subsection 10 of section 123 appears or is brought before the magistrate or the court, or the magistrate or the court shall cancel the bond executed by such person and shall order such person to give for the unexpired portion of the term of such bond fresh security of the same description as the original security. Every such order shall, for the purpose of section 120 to 123, what are 120 to 23? 120 talks about content, 121 surety, 122 default, both inclusive, and 123 talks about release, deemed to be an order made under section 106 and 117 as the case may be. Okay.